Just as a brief introduction, good afternoon. My name is Jeff Bacon. I'm a staff attorney here at the Alaska Native Justice Center. I'm a member of the Native Village of Tanana. My parents are Glenn and Adele Bacon of Fairbanks, and my grandparents are the late Michael and Eleanor Michelle Fairbanks, and the late Francis and Joseph McCullough of Wyoming. I'm pleased to be joined with several of my colleagues today. First, Charlie Kidd, he's the Tribal Justice Supervising Attorney. You may have interacted with him if you've received legal services from ANJC or if you've come to one of our trainings for tribal courts. Also, I welcome Kayla Ewert. She's our project manager, and she's one of the people who helped put on this presentation today, get the word out, and we'll be helping follow up with additional information after we conclude. So we will be able to email the slides after today. Can't promise it's going to be right the minute after, but we'll get those out as soon as they're ready to share, as well as some other documents so you have those with you. And again, our goal is to make this a useful opportunity for you as tribal leaders. I'm also joined by Robin Lidecker. She's our law fellow here at ANJC. And in a couple hours, she's about to become another attorney licensed in the state of Alaska. So if you need an attorney, she's there for you. So we've got a great group of expertise here at the Alaska Native Justice Center. And just for my sense of the audience we're speaking to today, if you wouldn't all mind sharing in the chat what tribe you're with and your role with the tribe or position in the tribe, or if you're here individual basis, that's awesome as well. Our goal is to present today for a non-legal audience so that it's useful for tribal leaders. I'm seeing a couple ICWA workers and tribal administrators from various villages and tribes here in Alaska. Additionally, if you have questions during the presentation, please put those questions in the chat as you have them so you don't have to think about them later. We'll take some pauses here and there throughout the presentation to try to answer those. And like any good attorney, if we don't have the information in front of us, or it's a really good question and it's complex and requires some research, we can follow up later. And at the end of the presentation, we'll just open it up to audio Q&A so we can have a back and forth discussion or particular questions or thoughts from tribal leaders. So looks like we got a representation from tribes all across Alaska, which is also really awesome. And again, the purpose of this is not just to have information that you can use and find useful. So I'll jump right in. So see if so today, our game plan for the next hour is to cover how the federal court system treats tribal records and documents currently, and what that means, as well as what there's a proposed rule change for how those records might be treated in the future, and what that might mean for tribes, especially Alaska tribes. And then at the end, we're going to talk about how you as tribal leaders and representatives of your tribes can have input on that proposed rule change. So this is our encouragement to get the word out that there is a consultation process happening right now. Every tribe in the country has received a notice, but I suspect that a lot of people got the notice and were confused by it because it's coming from the court system as opposed to the Department of Interior or the Indian Health Service. And so, again, trying to get the word out. So, and again, if you have questions throughout, if I don't see them, I'm going to ask that Kayla just flag me down and say we have a question, and we can tackle that question when we get to those pause points. So what is the purpose of, what do I mean when I talk about tribal records in federal court? Well, when you're going to court as a party, whether you're a tribe or non-tribal party, you have to have evidence of your claim. And that evidence typically comes from either people testifying in court or documentary evidence, photographs, things of that nature. And so when you have a documentary evidence item, so not testimony, but a piece of paper, the first step is to make sure that that piece of paper is admissible as evidence in court. And so there's a set of rules that every court system in Alaska and in the country has. So the federal court system has their set of rules of evidence. The state of Alaska has a rule of evidence. Every other state as well has their own separate rule, because each sovereign court is empowered to control their rules of evidence in their court. And tribes have this, and typically you might see it in the tribal court code where it talks about how tribal judges can consider things. And it may be as simple as if the tribal judge considers it trustworthy, it can be considered as evidence. And so that middle step is what we're talking about today, is because if you have a tribal court document, it has to be admitted as evidence for the court to consider in federal court or in state court. And so this very simple graphic is just highlighting that the rules of evidence are designed to keep things out of evidence unless they're admitted in a certain rigid way, which means that sometimes things aren't considered by courts when that information would be helpful for those judges. And so the idea is to try to help you understand what this rule does in terms of those tribal documents being considered as evidence. So I'll pause right here. Looks like there's a question from Lisa Alana. Hello. Can you please share a little more about the DTL letter? Yes. Yes, we can. Thank you for the question. I'll make the note of that. So the federal rules of evidence are there's about 100 different rules of evidence. And the ones we're talking about today is Rule 902. And that 901, 902, and 903 talk about this process of verifying the authenticity of any documents. And so Rule 902, subsection 1 and subsection 2 address this concept of public documents that are, quote, self-authenticating, which means that by looking at the piece of paper, we don't question its authenticity. And if we do, we have other reasons to question it. It's not just some random piece of paper that we find on the ground. And Rule 902.1 talks about self-authenticating documents that come from sovereign governments. So those are any document with a seal, a stamp seal of the United States, any of the 50 states, the districts, so the District of Columbia, Commonwealth would be like Puerto Rico. Territory, since statehood, we don't have many of those, but there are a few territories in the Pacific region, as well as in the Virgin Islands, and as well as those insular possessions of the United States. And so again, this applies to pretty much every kind of government that's in the United States federal system. So the federal government, states, and federally operated territories. And it even includes former sovereigns or entities. So you have the Panama Canal Zone, which no longer exists, or the Trust Territory of the Pacific Islands, which again, no longer exists, but their documents may be out there and maybe need to be used in court today. It also includes political subdivisions of any of those entities. So not just states, but counties and boroughs. Not just counties and boroughs, but departments. So like Department of Health, Office of Children's Services, agencies. So things that are sub-sovereign. So that's, again, it's a very broad list, but as you can see, tribes, federally recognized tribes are not included in that list. Part 2 takes that same group of sovereigns and sovereigns subdivision entities and says that even if there's not a seal on those documents, another public official with a seal can certify that those are genuine documents from that sovereign. And so it's a way for documents to be considered by court without that extra step of having to have a witness testify about its authenticity. And there's about 14 different subsections of this Rule 902. And it's not just about government documents, but different kinds of documents where the federal court system and other court systems are less concerned about questioning the authenticity of a record or a document. So looking at there's, looks like Kayla's already addressed the questions about the slides, so I'll keep plugging away. But this is the rule that we're looking at today, and this is the rule that the federal court system is looking at amending. And that self-authentication doesn't just apply to the departments of the federal government, like Homeland Security, Health and Human Services, Interior. It also applies to federal corporations or those things that we don't think of as a department. So for example, long ago, the Postal Service was held by a circuit court. So it has authority, that's an agency under the rules. And a different circuit court said that the Federal Deposit Insurance Corporation, which is the government managed corporation that insures banks to make sure that they are solvent and protects savers' money in those accounts, was also an agency. And those are things that operate more as independent companies or entities than truly departments in a very rigid box of hierarchy. So again, this rule has a broad application of what things are considered self-authentic, or what agencies can be self-authenticated. Again, you have to have a seal. So if you don't have a seal, then you can't really rely on this this rule to get your documents considered. But tribal governments usually typically have a seal and can create organizations with their own legislation. So I can't no court that I'm aware of has ruled on tribally created entities, as well as if those records are applicable in this exception. There are other ways to introduce business records. And so I don't want to scare anybody with thinking about this being a radical change in terms of how tribal business records can be considered. Okay. Oh. So, and this may be the big question of why everyone's here today, is how might this impact your tribe? And this answer is focusing particularly on Alaska tribes. There are other issues in tribes in the lower 48, particularly in Oklahoma, where there's larger reservations and the federal government is the only law enforcement authority for major crimes, that of the tribe. And so you have a lot of federal prosecutions that require the use and admission of tribal records. That's less important in Alaska because we are what is called a PL2A state, where the state court and state police are the ones who have primary law enforcement authority in Alaska for reservations, allotments, and just other types of land in Alaska. And the federal government does not prosecute like they do in the lower 48 reservations. So how might this impact? And this is also looking forward as tribes assert their jurisdiction and their tribal courts. The first line up there is about the special tribal criminal jurisdiction under the Alaska pilot program. So these are, some of you may be members of tribes that are participating in asserting special criminal jurisdiction for non-native people. Additionally, the VAWA 22 amendments that empowered tribes to have inherent civil and criminal authority over all native people in their village is implicated by this, because one of the ways that you prove a person is a native person under that statutory authority is by their tribal enrollment or their affiliation with the tribe. So if someone is enrolled in a tribe and their CAB card has a seal of the tribe on it, that could be used as evidence in federal court under this proposed rule change to verify their enrollment and native status for purposes of civil and criminal jurisdiction. And that may come up even now if a person is saying, I am not subject to the tribe's jurisdiction, and goes to federal court to try to stop the tribe from protecting themselves through civil or criminal proceedings. It becomes more important when, if a tribe were to use their arrest powers under a criminal process, because the Indian Civil Rights Act provides for specific right in federal court for a habeas petition, which means that you as the person incarcerated get to file a claim in federal court saying that this tribe does not have authority to detain me. And so that could be based on them saying, I am not a native person, the tribe doesn't have authority under VAWA or under federal law to detain me. And so the tribe having records of enrollment, receipt of services, are going to want to be able to present that in federal court, and this self-authentication process would make that an easier step. The second aspect where this might come into play is as tribes are empowering and protecting their membership and their citizens by issuing and enforcing domestic violence protective orders under federal law, or other types of judicial acts. Those are documents typically signed by the tribal judge with the court seal on it. And so under federal law, the federal government can prosecute people who have protective orders against them who are in possession of firearms if they're a dangerous person, or if they're found to be a dangerous person. I'm not going to go into the details of that particular elements of that particular federal crime, but proving that there is a valid protective order in place is an important part of proving that crime happened. So again, having the ability to say this is a valid tribal order and here it is signed and sealed by the judge makes proving that part much easier than if you have to have someone from the tribe testify about the actual proceedings and the actual authenticity of that tribal court record. And I'll get into a little bit later about the difference between self-authentication for evidence purposes and full faith and credit for enforcement purposes, if that's a question that's coming to your mind right now. And finally, the other thing that how it may impact your tribe is that if the federal government does something in terms of their court proceedings, there is pressure on the states to think about doing it too. We'll talk about the states who have currently already done this self-authentication rule, but it could pressure Alaska to say yes. Now, there currently is a request under consideration to apply the same, add tribes to this list of self-authenticating governments in Alaska courts, which have a much stronger impact on Alaska tribes because of the tribe's involvement in federal court. But that rule hasn't been approved yet, but it is pending. I can pause here to see if there's any questions. If not seeing any, so I'm leaving everybody speechless, which is always a good thing when you're an attorney. And as I talked before a bit, most tribal courts don't have this evidence gatekeeping process. And so the concept of a document being self-authenticating, and if you really doubt it's a real document, having that discussion in court, but not forcing someone to prove something's real, is more consistent with tribal courts of wanting to actually hear the evidence and make a decision by the judge instead of worrying about what the evidence the judge can consider. And again, our work with tribes in developing tribal court codes and our experience working with tribes across Alaska, it's most tribes do not have a separate rules of evidence designed to prevent their judges from hearing certain things. And you may have experienced this yourself with questions about hearsay being introduced in court. And that's another example of where in many Western courts, Alaska, federal court, this idea of hearsay or I heard something from someone and so I'm repeating it in court and saying that's what they said to me to the court and saying that what they said to me is true. Some tribal courts consider that and just weigh it, the credibility of the person who said it and the person who repeated it. But under a Western process, there's an exception of you can't consider it, but there's numerous exceptions to allow it in. And again, it's that gatekeeping process of what evidence the judge can hear and making it easier to introduce evidence into court is consistent with how tribal courts have treated evidence in our experience. And as I said before, several courts in states across the country have already adopted a rule where tribal court records are self-authenticating, just as federal or state court records are. And as you can see, Arizona and New Mexico are homes to some very large tribes, as well as Oregon and Washington have a lot of tribal homelands in their borders. And so these are not courts that are unfamiliar with tribes and recognize the value of treating them with the same respect that they would treat other counties or states across the country. Wisconsin is unique in that it's separate from these Western states, but it is also less unique because it's a PL280 state like Alaska is. So their court is also very familiar with tribes. Their court has also worked hard to establish a collegiate relationship with tribes where tribes share borders with states, and recognizing and respecting the work of each court. And so it makes sense that where state courts are familiar and trusting and have relationships with tribal courts, there's less concern about adding tribes to the list of self-authenticating records. So self-authenticating records is different. It's a different concept than the full faith and credit that tribal court orders are entitled, or certain tribal court orders are entitled under the Violence Against Women's Act or under federal law about tribal child support orders. Self-authentication just speaks to records or documents that another government has created. And it just says that those are easier to be considered. You don't have to go through the extra step of proving that they're genuine. And it doesn't apply just to court orders. It can be any kind of document where there's a seal. So again, the tribal enrollment or tribal IDs or things of that nature. Contrast that with a full faith and credit concept. That is where you have a tribal court order, so signed by a judge, and it's a certain kind of order, so a protective order, child support order, or a child protection order where the state or the tribe has assumed custody of a child, for similar to a child need of aid case in state court in Alaska. That's where the court has to respect the order and follow it just like it would its own orders. So it's a slightly different concept The parallels is this idea of respect and treating a tribe as you would treat a state. And so there is some themes between the two concepts, but they have different legal purposes and they do different things. Again, the audience must be answering all the questions ahead of time. So if you come think of one, please don't hesitate to drop it in the chat, and we'll have time at the end to talk, um, open up the mics and have questions, and you can ask the really tough questions that might require some research. So I just wanted to highlight that there is a federal rule process. As any federal bureaucracy, it's a multi-step process. And the first step is this evidence subcommittee. And so that's the subcommittee that just focuses on the federal rule of evidence. There's other procedural rules. So there's civil procedure, criminal procedure, appeals, and that's similar with state courts as well. So some of you may be familiar with the Alaska court system, where you have a civil procedure, criminal procedure, evidence, and for Alaska, the child need of aid rules. And so the evidence subcommittee focuses on proposals to change the evidence rules. If they are advancing a change, then that goes to the standing committee of procedural rules. And they look at it and decide whether or not they should advance it to what's called the judicial conference, which these are judges, people that are familiar with the court system, so practitioners, Supreme Court justices are getting involved at a certain level, because the idea is they want to thoroughly vet these things, because when you make a rule, every court in the country has to follow it. And so you don't make those changes quickly or without thought. So they're asking for feedback, they're asking for perspectives, asking for public comment. And once it gets to the judicial conference, if they think it should be a change, then it goes to the Supreme Court. So the 9 people that have made some very intense decisions in the last decade are the ones who approve the final changes of anything that would happen year to year. So every year there's a consideration and a revision of the rules. And so you may see this in state court, where in court the color books change every year. So I think this year it's purple, last year it was green. And then if the Supreme Court says we like the rule changes, then Congress has the chance to disapprove them. So they, like Congress, don't have to do anything to approve it. If they don't do anything, then it becomes the new rule. So it's a very long process. And it could be 1 year, it could be 2 years before something that starts at the subcommittee of evidence makes it all the way to the final rules. And I had an animation here, but it's not working for the moment. But we are currently at the evidence subcommittee phase. So we are early in this process. But it's important because we're actually on the process as opposed to asking to start the process. Okay, I saw a question. Question from Aaron was, is there somewhere we can track the process or offer public comment on general rules in general? And the answer is yes. So Kayla shared a link to the proposed changes for this rules. There's again, anytime somebody proposes something, you can propose your own change if you want, as an individual or as a tribe. There's comments on those. It's under the federal court system website, and so they have public comment for ones that are farther along the process as well. And we can also put that in our follow-up email too. Great question. So currently, with the proposed rule change to include tribes amongst the sovereigns whose documents are self-authenticating, there are perspectives. And so already And the primary reason why this change could actually happen is because the Federal Department of Justice is supportive of this change. And they're doing it primarily because in Oklahoma, where under the Supreme Court ruling, McGirt, that recognized that the tribes of Oklahoma never lost their reservation status, and half of Oklahoma became reservation boundaries and subject to federal jurisdiction for criminal prosecution of Native people. That has meant that the federal government has to go into court day after day proving a person is a Native person and their victim is a Native or non-Native person for that criminal prosecution. And there have been at least 2 appeals where the federal government didn't prove the Native status under an appropriate evidentiary rule, and the conviction was overturned. And so this change would make that enforcement of federal law for people who are abusive towards their partners, commit major crimes. So these are serious felonies. This would make that prosecution a little less procedurally complex because you could introduce the tribal enrollment record to prove Native status. Additionally, there are recently 5 U.S. District Court judges who are all trial members also signed a letter endorsing this change. Now, these are practicing attorneys who then got appointed, nominated by the president and confirmed by the Senate to be federal district court judges across the United States. And each of them is supportive of this rule change. And fundamentally, what the supporters argue is this change is a respect of tribes as sovereigns. And I said the word respect previously today. You're treating tribes as you would states, and you're showing the tribal records of the records of a tribe with the same respect and authentic belief in authenticity as you would a state or a county or a small town with 1 or 2 people in it. And again, there's this efficiency argument of if we don't have a question about these records being authentic, why not make this a little easier for this evidence to be considered by the judge, to allow the court or the jury to know what's going on and to weigh the evidence instead of letting a judge keep it out. On the critics of the rule change, the ones who say we don't need the rule change, so far the Nevada federal public defenders have been the one group or person to actually say that the rule should not be considered or advanced. They raised a couple of things. One, they raised concerns about the integrity of tribal record keeping. I don't know of any county or city in the country that has the same stress of trying to track who is a member of the tribe. But that certainly has to be very stressful in making sure that that's accurate. I disagree. I take issue with their concern about integrity because who's a member and who's not a member is something tribes are very good at. And I would question whether every county in this country or every city in this country is great at record keeping either, particularly the small ones. The other thing they point to is that there are other ways to authenticate tribal records. As I said before, a person can always testify about the authenticity if the person has knowledge about the authenticity. So a tribal record custodian could testify. And so there are always ways to authenticate something, but it takes time. That person would have to testify in court on a certain trial day and be available. And as many of you are aware, sometimes the internet doesn't work. And if it's a criminal proceeding, the person has to typically appear in court because you have the right to confront all of the witnesses in person. And so, yes, there are other ways to do it, but the idea is that if we're not worried about the risk of inauthenticity, why are we making it harder for these records to be considered in court? So, and Kayla has dropped in the chat links to these 3 different documents. So each of these, so the Federal Department of Justice, these district court judges, and the Nevada public defenders have all written letters supporting or against this proposed rule change and submitted to the court system for consideration. So it becomes part of the record that the committees look at. And so it's important that if tribes are supportive or if they have concerns, that their voice be part of this process. And so getting to Elisa's question about the Dear Tribal Leader letter, this is your opportunity as a tribe to voice what your tribe thinks should be done here. And we're not promising it, again, not promising it today, but we will follow up with these slides, and we'll also follow up with just a simple template of how to caption the letter you may send to the court system. So, insert your tribal letterhead, the name formatting for the person you're sending it to. The chair of the committee is Judge Furman. You may have received you should have received an email from the court system with a cover letter from him announcing this proposed change, and at least the first 2 of those comments from the Department of Justice. And so the court system has asked for tribal comment through the 1st of March of next year. So there's time. And at ANJC, one of the things we do is assist tribes and provide assistance in helping tribes enhance and empower their tribal justice systems and how those systems are respected by other courts, such as the state of Alaska. And here it's federal court. And so if a particular tribe is looking for assistance, I think Kayla has already put our email in the chat. We'll also have that in our follow-up email, just outlining how if a particular tribe wants to meet with ANJC attorneys individually to receive particular advice or recommendations, we're happy to do that. If there is a desire by multiple tribes to have a community forum on like a virtual forum where we can all talk about it together, that's something we're open to supporting as well, similar to how we worked on trying to respond to the civil diversion agreement process with the state of Alaska recently. Again, our goal is to empower tribes, particularly Alaska. But again, this applies to every tribe in the country, all 574 of us. We want voices to be heard, because if you submit your comment from your tribe, they will read it and that will become part of the record. And one of the reasons this proposed change didn't move 10 years or 12 years ago when it was proposed in 2013 was because the committee was like, we don't know if the tribes are supportive. We'd probably have to do some kind of consultation. And again, the court system is not an expert in consultation. Thank you, Kelly, for putting our email in the chat as well as our phone number. So having that tribal voice is very important in this process because it's a meaningful opportunity to let the federal government know what your tribe wants. And it's a different branch than the executive. So they're, again, not as familiar, but they are asking. And so we're recommending that when you draft up your letter, and it can be long or short, that you email it to the Rules Committee email address that's on this slide by the deadline so that it can be considered along with every other tribe. I hope I answered your question, Elisa. If I didn't, I'm happy to dig into it more. And that really brings us to the end of our prepared presentation. We have a QR code here. We'd love you to scan, give us your feedback. We're looking to make these things meaningful, and if there's ways we can improve the information we share, we always value that because we understand the tribal leaders and tribal employees. You have probably about 15 different hats you wear, and taking time out to listen to us is we really appreciate that. And anything we can do to make that burden a little bit lighter, and have your tribe have, enhance your tribe's impact in the work it does, that makes our day. And thank you all for spending time this afternoon